Hi, my name is Mark D. Copoulos, and I'm a Philadelphia civil defense and real estate lawyer. And today I'd like to talk a little bit about valuation of personal injury cases and why just because you've been sued for hundreds of thousands of dollars doesn't necessarily mean that you're going to be liable for that amount. When a plaintiff files a civil lawsuit, they choose the value of the case. They have an option to file the case either as a small claim, an arbitration case, which is up to $50,000, or a majors case in the Philadelphia Court of Common Pleas. And if you think about this from the plaintiff's perspective, if you're a plaintiff and you're suing for injuries, of course you're going to ask for the sun, the moon, and the stars. You're going to say, well, I was injured and I'm entitled to the compensation that I deserve for my injuries. But oftentimes over the course of litigation, it becomes clear either that the plaintiff cannot prove that the injuries are the responsibility of the defendant, that is, that the defendant is liable in any way because they failed to exercise reasonable care and as a result the plaintiff suffered an injury, or that the plaintiff's injury is actually sustained an injury on the premises. And a lot of times plaintiff's lawyers will file cases. They will colloquially refer to them as pro bono or perhaps low bono cases. A low bono case being a case that's essentially filed for free on behalf of an indigent individual, and there's a small fee taken by the law firm. And they'll sue for hundreds of thousands of dollars. But really, there's not great expectations for that case. And in reality, when it comes to prosecuting a case like that, if there's an aggressive defense, the plaintiff is not going to invest thousands of dollars into retaining experts, spend hours and hours in litigation, in discovery motions, in depositions, getting prepared for the case, if it is what is colloquially referred to as a low bono or a pro bono case. Now, sometimes they might. Certainly, if the injuries are there, they might. If liability's there, they might. But a lot of times, a plaintiff will file a case. They will sue for damages. They will sue for hundreds of thousands of dollars. And 2 years later, when the case sits down for settlement, the plaintiff will accept pennies on the dollar because they know that they can't prove liability or that they simply do not have the damages. So if you are a homeowner, if you are a dog owner, if you are an individual who has been sued and you've been sued for hundreds of thousands or even $1 million, understand that is the plaintiff's valuation of the case. It is the most optimistic valuation that anyone is going to assess to that case because it is the plaintiff who is assessing the value at the beginning of the case. But when the case gets to settlement, there's going to be someone from the court kind of assessing the value of that case. If and when the case ever gets to trial, it'll be the jury or the judge assessing the value of the case. And oftentimes, the difference between the plaintiff's valuation and reality is thousands, tens of thousands, or hundreds of thousands of dollars. And that's one of the reasons why it's so important to assess a case at the outset, if possible. A lot of times when you get sued, you don't have all the cards on the table. You don't know how seriously injured the plaintiff is. But is this a legitimate injury that was suffered? Or is this what's kind of referred to as the low bono, pro bono case, where the plaintiff is seeking the sun, the moon, and the stars, but simply doesn't have the cards to recover a six-figure verdict at trial? And that's where a defense lawyer can help you if they've walked that path before. And that is where an aggressive defense becomes critical. Because if a plaintiff can get a major recovery easily, of course they'll take it. But if the defendant has an attorney who's digging into the case, who's aggressively defending the case, who's making the plaintiff work, then at some point they may just throw up their hands and concede that this is a low bono case. This is not a big value case. We simply cannot afford to put more time and money into this case. And as a result, they will settle. They may settle for pennies on the dollar. Now, obviously, that's not every case. If there's a substantial injury that was suffered, that's a different analysis. But it's just important to understand, if you've been sued and you get that paperwork and it says hundreds of thousands of dollars in damages, it doesn't necessarily mean the plaintiff is going to get that if it goes to trial. And another relevant consideration is whether you, the defendant, have insurance. Because if you're not insured, the personal injury lawyer is going to look at that case differently than if you have an insurance policy. Because if the defendant has a policy, the plaintiff's lawyer knows that there's a much higher likelihood that they will actually receive compensation. But if the defendant is not collectible, or if the defendant doesn't have assets, then again, that may be another consideration in settling for far less than what was originally pled in the complaint. My name is Mark D. Copoulos. I'm a Philadelphia civil defense and real estate lawyer. And if you've been sued for a premises liability action, a dog bite, or a similar accident claim, and you're seeking defense because you don't have insurance, call my office. We'd be happy to give you a free consultation. And remember, it's the plaintiff's burden to prove, more likely than not, that but for the defendant's negligence, the injury would not have occurred. And it's also their burden to prove damages. And if they cannot meet their burden, then you may have no liability under the law. And just because you've been sued doesn't mean the plaintiff is entitled to a monetary award. My name is Mark D. Copoulos. I'm a Philadelphia civil defense and real estate lawyer. If you have any questions, feel free to give us a call at 267-535-9776. And as always, thank you for watching my blog. Have a great night.